Car crash cases, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you. Your tough legal questions answered by our experts. The attorneys with Josh Wright from the law firm of Hollis Wright and host David Lamb.
Hello and welcome into the attorneys. Thank you so much for joining us on this Sunday evening. We appreciate the opportunity that you give us each and every week for the next half hour. The way this is going to work is there is a panel of experts assembled, and we're going to cover a topic that we believe is of interest to you. And the hope is that it will trigger some questions that you would like answered. That's why we make it really easy. Right at the bottom of the screen, there are ways you can contact us. Also, a really neat thing that the firm of Hollis Wright offers each and every Sunday night is attorneys are standing by live. So if you would like to get some great free advice from an attorney standing by to speak with you, just pick up that phone and give them a call. A neat thing that Hollis Wright offers each and every Sunday night. From the firm of Hollis Wright, managing partner Josh Wright, good to see you.
You too, and I think, some people try and challenge us sometimes on whether or not we actually will respond to a text or an email or a call, but that's what we do. I mean, it's part of the service. The service is to provide legal advice to people that have questions that could impact their lives, and I think we do a pretty good job of that.
Absolutely, you guys do. I hear a lot about the folks that connect with you all. Another service that you all do each and every Sunday night. This show is about informing, educating the public. What are we going to talk about tonight?
Tonight we're talking about a really important topic that impacts a lot of people, which is premises liability, and that is circumstances where people have been injured at no fault of their own related to a premises or a condition. And when we talk about this kind of stuff, we bring on a guy that is an expert in this area of the law, Logan with the Alexander Shunnarah Injury Lawyers. They're a group that we've heard about for years and years. They do a great job helping people in our society and helping people in our viewing audience. And Logan is a huge component of that. This is not all he does, but this is a component of what he does and does a great job on it. So first of all,
Josh, thank you very much for having me.
Thanks for being on. And Logan is not only a great lawyer in this area, he's a personal friend of mine that I see and talk with quite often, and weekly we bounce ideas off each other on cases and things like that. So I love having him as an ally and a friend and a colleague in the legal industry. All right, let's talk about our topic a little bit. Qualifying an individual, and you and I can both kind of tag team on this because we handle some of this stuff too, but qualifying an individual or what condition you're in has an impact, does it not, on really what duty a landowner may owe to you. Is that fair?
There's no question about that, and really and truly there are three statuses that a person has that would entail whether or not a person is owed a duty by a landowner or a property owner or someone else. There are three classifications. Like I said, the first would be an invitee. That would be an individual who, for one reason or another, has come onto the premises or onto the property of another for a business purpose. If that individual comes onto that premises, then you owe him a duty to make sure that the land or the property is reasonably safe.
Yeah, and David, one of the interesting things is people just look at premises liability a lot of times and they think, this is just slip and fall cases, and that's not the case at all. Let's take a couple examples. The airport case where the structure fell on the young boy and the mother. Terrible, terrible circumstance. That falls under the concept of negligence, but it also falls under the concept of premises liability. We deal with cases, and I know that Logan's firm deals with cases where children, for example, are injured on ball fields where there are holes and things that have happened where people break legs and ankles and whatnot. And so qualifying an individual as an invitee, or what we'll talk about in a minute, licensed or trespasser, really impacts what condition they have. The other thing I'd mention is this. The legislature is always putting out new laws related to these classifications for hunters, for example, or those that come on the premises of another for gaming purposes, and all those things play into kind of our topic today. But let's talk a little bit about the other qualifications or circumstances somebody can fall under.
Right. The second classification that a person would fall under would be a licensee, and that would be a person who would naturally come onto the premises or the property as with an implied or an express consent to visit the property. Many times it can be seen as a social guest or someone that you have personally said, please come onto my property for whatever purpose it might be. Now, for that person, the duty's a little bit higher. You've got an express concern to make sure that the property is free of any kind of dangers and to fix those dangers or those potential hazards so that the person is not injured on your property.
Let's talk about trespass too, because now, and this comes in a lot of different, you could really unwrap this because it comes in a lot of different categories. We're not just talking about people that are breaking the law trespassing. Sometimes people don't even know that they're trespassing, or sometimes we have children that are trespassing on others' property. There are still duties that are owed even to those individuals, aren't there?
Sure, and you know, it's actually a very good segue from a licensee, because a licensee as a social guest, if they are told to leave or to remove themselves from the premises, actually becomes a trespasser at that point. Now, a trespasser is owed slightly less of a duty than a licensee or a invitee. Generally, what qualifies a trespasser, that's someone that enters the property without any express or implied consent, and then that individual, for them, the owner of the property is simply not supposed to allow any sort of hazard or dangerous condition. They're not supposed to. Can we break?
Yeah, you know, I think that's 100% right. Is at the end of the day, you know, the standards are different and unique, and so a trespasser, you know, may still have certain rights that a licensee or an invitee does not have, and so a lot of it depends. And really, the first step here is to classify the individual in such a way that you determine what duty is owed. And that's kind of an important component to it.
We need to take a break. All right, whenever this is our first break of the evening, we're going to come right back. We'll pick up right here at this point and actually get into some of the different types of cases maybe as we come back to kind of put some flesh on these bones as we talk about premises liability. As we head to break, a reminder, we'd love to have you join our conversation. There are ways you can do so. It's always better whenever you are involved. Stay tuned. More of the attorneys coming right up.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm. Thank you for watching The Attorneys. Now, we hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple. Provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to the show or related to other accident or injury-related topics, you can call, email, or text us. Or you can also follow us on Facebook or Twitter, or simply contact us by going to hollis-wright.com and click on the Contact Us link. We know your time is valuable, so thank you for spending it with us watching The Attorneys.
Welcome back into The Attorneys, talking about premises liability, and we'd love to have you be a part of the conversation. That information at the bottom of your screen. Also, attorneys from the firm Hollis Wright standing by even as we speak to talk with you, so take advantage of that opportunity. We kind of, in the first segment, an overview, the 30,000-foot view, if you will. But help us understand this a little bit more. What are some types of cases we're talking about here?
Yeah, go ahead, Logan.
You know, the most common type of premises liability case would obviously be a slip and fall type case where an individual's hurt on a premises, whether it be a business or whatnot, that there's mopped floors, maybe the floor is wet from some sort of slippery substance being spilled on the floor. A common complaint that we see at our firm is, where a person is in a grocery store, maybe some fruit or some sort of juice is spilled on the floor and the person slips in it. And then there's a number of other things where there could be a defect with the flooring. There might be torn carpet or broken tiles. A person can even be injured on a city or a public sidewalk where there might be crumbling sidewalk, or where it's broken up and is just in a state of disrepair.
Yeah, you know, we see cases, and Logan does too, because he and I have worked these cases together. You know, some examples. We see cases where bikers are out using our roads, and a construction company may have come in and they're working on piping, whether it be gas piping or water piping, and don't finish the work that they're supposed to the night before, leaving an obstruction somewhere that nobody would even recognize. And when we talk about catastrophic injuries, I could give you story after story after story, and Logan could too, of some significant catastrophic injuries that people have, brain injuries and even worse, related to those events, where we've litigated those cases, and Logan's firm has too. I deal a lot in the pool context, in pool drowning with children. And there still are certain duties that individuals that have pools have with reference to closing a perimeter off and providing other forms of equipment in a commercial context, warning signs and those types of things. So, you know, we deal with those types of cases a lot, and I know Logan's firm does a ton of that work also. There are certain duties that are owed, and a landlord has a responsibility, or a construction crew has a responsibility, or a municipal entity has a responsibility to make sure that they comply with those duties to protect average citizens.
How about, and you're seeing this a whole lot in the news now, kind of like events that where there's some sort of an attack, someone with nefarious intentions, either a bomb goes off or shootings and that sort of thing. So what about like nightclub injuries and that sort of aspect? Is that also fall in line here?
It's a great question, by the way.
That is a great question, and one of the things that we have to look at when anyone calls us about an injury that occurs in a nightclub, especially if it's at the hands of another person, was there adequate security on the premises? Have they staffed themselves appropriately, and have they trained their staff appropriately? You know, some of these venues that hold concerts or other social gatherings, when there's a large group of people, those individuals, you know, may sometimes come into harm's way. That's just simply something that any of these places have to prepare for and have to prepare their staffs for.
Yeah. And a lot of times, one of the problems there is those staffs are too small. You know, I think we naturally believe when we go through a metal detector at an event that we're more protected than we may actually be. If you're going to have metal detectors, and I'm not just talking about airports, I'm talking about a lot of other venues.
Most every concert, every sporting event you go to.
No question. I mean, a lot of times when you go to a football game now, you're going through a metal detector. And, you know, when you have metal detectors, there are certain responsibilities and duties, as Logan was alluding to, that you have to do it the right way. All those things, interestingly enough, fall under the topic of premises liability. And of course, there's a whole area of the law that we won't talk about today, which is just general negligence. But premises liability plays into a lot of those circumstances to figure out, first, what duty does the landowner, the property owner, the person running that venue, what duty do they have to the typical individual like us coming into that venue? And so we talked earlier about the licensee, invitee, and trespasser. Go ahead. I didn't know if you had anything else, but those duties matter.
You know, another thing that we get into on certain properties such as this may be staircase injuries. Many times these properties, they may not have proper railing, they may not have proper treads on the staircases. You know, there's a number of things at nightclubs where, you know, we may have falls, slips. A premises liability case also extends to an auto accident. It can, because it actually happens, if it happens on the private property of the club or the facility, that is in fact a premises case.
Let me ask you a question, and this one has a question we've got here, and this has to do with governmental property. What if I'm injured on governmental property? Is there a special rule for those kinds of claims?
Sure. You know, with any municipality or any state government, you've got to file a notice with that state government or that municipal government. Most have a requirement that you file a notice of claim within a 6 month to a 1 year limit. If you fail to do that, then you fail to have a claim against that municipality or that state government. The normal statute of limitations on any kind of injury claim here in the state of Alabama is 2 years, but it is different when you have a municipality or a government institution involved.
I don't think that can be said enough. And I'm going to say it again because the point that Logan just made is a super critical one, and that is this. If you're involved in an event, whether it relate to a venue, inadequate security, a premises claim where you've been injured, slip and fall, you have to identify not only what circumstances you are, whether you're a licensee, an invitee, or a trespasser under the law, but you also have to get with counsel quickly to determine, for example, whether or not there may be a 6-month notice of claim or a 12-month notice of claim. Because a lot of times in the premises liability category, that's not a statute of limitation like we talk about on this show, but it's a notice of claim that's required if you want to bring suit against the municipality. You have to provide notice to them, for example, within a 6-month period, or a county notice to them within a 12-month period. If you don't provide that notice, you don't have the ability to bring suit against them. So Logan's point is really well made. You want to get to counsel quickly, and that was going to lead me into a question that I had for you, Logan, which I know you can knock out of the park, and that's this. You know, if you've been involved, for example, in a premises event, what do you recommend? What should they do? I mean, is it as simple as taking pictures and finding witnesses? I mean, what should they do so that they preserve, if you will, that claim down the road?
You know, any pictures of the incident scene in the manner in which it was set up that you can get, that's incredibly important. Now, sometimes that's not always the easiest thing to get because obviously if a person's been injured, you may not be able to take pictures, or you may not be of a mind to take pictures. If there are any witnesses that are on hand, obviously getting a statement from them, getting their name, their telephone number, some way to contact them afterwards is incredibly important, because you can't count on the store or the facility to get their name and number for you. They're most likely not going to help you with that aspect of this. You know, I guess what I would also say is any pictures that you can provide to your attorney of injuries that you have, any swelling, bruising, cuts, lacerations, anything of that nature, while it's fresh and while it's clean, is probably going to be better than getting something down the road.
We see a lot of these premises claims in construction sites. I mean, there's a lot of construction going on right now where there's some very significant injuries. And there are duties that those that are building homes, but not just building homes, the builders themselves have duties to protect, for example, for children, younger adults, those types of folks. When we come back, because I think we're getting ready to go to break, I want to talk a little bit, and we talk sometimes about it, how important a contingency fee contract is in these circumstances. I know Logan can answer that question too, because that's a critical component to allowing people to be able to have good legal counsel to evaluate these cases.
That's a good stepping off point right there. We'll head to break, our final break of the evening. So the clock is ticking. If you want to join the conversation, go ahead and take advantage of that opportunity. Also, a reminder, follow the firm on Facebook. You can track them down there. Just search the term Hollis Wright. And on Twitter, it's Hollis_Wright. Stay tuned. More of the attorneys coming right up.
I'm Carter Clay with the law firm of Hollis Wright. When someone whose unreasonable conduct causes an injury to someone else, the law says that person is negligent. So it seems the injured person should receive some type of damages, right? Not always so in Alabama. In tonight's Legal 411, we answer the question, what is contributory negligence and comparative fault? Alabama is one of only 4 states in the nation to withhold damages based on contributory negligence, meaning if you are at fault even just a little, you cannot be allowed any damages in a case. For example, in a case where a defendant may be 99% at fault for hurting you, if you are found to be 1% at fault, Alabama law says you get nothing. 4 states, Virginia, North Carolina, Maryland, and Alabama, plus the District of Columbia, are the only places in the country where a defendant can completely avoid paying if the injured person is even 1% at fault. This is very different from comparative fault, the measure used in 46 states. There are 2 versions of this system, but both essentially allow money damages based on the percentages. For example, if the injured person was 20% at fault for causing an accident, then the recovery for medical bills and wages is reduced by 20%. Numerous studies across the country show that people who live in comparative fault states believe this system of justice is more fair. Please remember your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will always respond to every question you send in. That's our pledge and promise to you.
Welcome back into the Attorneys, our final segment of the show. Time always seems to fly on these programs. Hey, if you're the kind of person who, texting is okay, but you really like to talk to somebody, the attorneys of Hollis Wright are standing by to speak with you. So if that's you and you'd rather just tell someone what your question is or your concern is, you can pick up the phone and call them again. Attorneys from Hollis Wright standing by as we speak. One of the terms that we've used over the couple hundred times we've done a show, you hear a lot, is the term contingency fee. Is that applicable with premises liability?
David, it is, and thank you for bringing that question up. A contingency fee is something that an attorney has with his client. It's simply a contract between the two of them. And as a personal injury attorney, we don't have a retainer fee. We're not on retainer. You don't pay us to do the work that we are going to do up front. A contingency fee basically is an agreement between the attorney and his client that says that if and when we are able to collect either a settlement or a verdict for you in a court of law, then we're to be paid a certain percentage of whatever we collect for you. It's a very good way. Number one, it serves as protection for the client because it keeps them from incurring any sort of unnecessary fees, costs, or expenses, and lets them know up front what will be due to the attorney once the case is resolved. And it also protects the attorney because it keeps the attorney's fee locked in from the get-go. So there's really no gray area between the attorney and his client.
And I often explain it, David, as leveling the playing field. It allows an individual that has been injured to have the same and equal capable lawyers as the other side does without having to front the money. And so Logan explained it exactly correctly, and leveling the playing field is a big component of what lawyers on the plaintiff side of the bar end up doing. And so it's another reason why whenever there's legislation either nationally or in Alabama that impacts the contingency fee contract, lawyers get super involved in that because it is a way that allows a regular individual like the three of us to have the same level of legal service as corporate America would have. And that's not to say corporate America is doing it the wrong way and plaintiffs are doing it the right way, because there are circumstances that work both ways, but it gives them, from a financial perspective, an equal footing, if you will, to be able to prosecute these claims.
Love the idea of leveling the playing field. A question we've got here, I heard you say, talking about leasing property and lease the property. Can the tenant of an apartment building be liable for an injury?
David, yes, absolutely they could be. I'll give you a specific example. If, let's say, a tenant has a dog that bites someone, and the landlord has noticed that that dog is owned by that tenant and that the dog has a dangerous propensity, meaning that it's of a breed that, kind of incites it to be more violent than, say, another dog breed. Then by virtue of that, the landlord and the tenant could both be liable for any injury sustained by the victim of the dog bite.
We see these claims a lot of times too, where premises have been leased for hunting. There's a very specific set of statutes in Alabama that relate to hunters and those that lease premises to hunters. The standard and duty is very low for those that lease the premises because of the dangerousness of hunting. There is still a standard there. There still is a requirement that you do certain things. For example, notify hunters of old mines and pitfalls and things that they would not be able to recognize on their own. So it's a low standard, but there is still a standard. But if you lease your premises, let's say you've got land somewhere and you lease it to a hunter and somebody has accidentally sprayed by a shotgun or shot on your premises and injured, the person that leased the premises doesn't sign on to protect people from that, right? But if there's a dangerous circumstance, you know that there's a bobcat on that property that has attacked individuals, and we all kind of look at that and kind of smile and say, "Wow, that's funny." That's a real case, okay?
real.
And if you know of things like that, you've got a duty to notify people, and you have a duty to put up signs that your property is there's certain barriers to your property so that you don't trespass into somebody else's property. So there are certain duties out there here and there that in a lease setting that you've got to make sure you're careful of. And a lot of times what happens is I'll get someone that calls me and says, "Hey, I know that you do this on the personal injury side, but can you give me a little bit of advice on what duty do I owe if I'm now inviting people on my premises because I have a home business?" And a lot of times we'll just provide good advice to them for that.
A little over 2 minutes remaining, but I want to give both of you the opportunity just for a final thought tonight, something you'd like to leave our viewers with. And Logan, I'll let you go first.
Sure. You know, I guess along the lines of what we've been talking about, for anyone out there who thinks that they have a slip and fall, a premises liability claim, I would just tell you that there's certain things that you need to verify. You need to verify if a defendant is an owner of a property. You need to find out if that defendant was negligent in the use of his property. But you also need to see if you as a plaintiff have an injury, and you also need to be able to determine if the defendant's negligence in the maintenance of their property was a cause of that injury. And then finally, I would just say, by all means, if you do believe that you have a valid claim, get to an attorney as quickly as possible. And do those things that we had suggested earlier with respect to gathering evidence through photographs, statements, witnesses, and other things that may be helpful to you in the long run.
Yeah, and I would just say, number one, I'm so glad Logan came on the show to talk about this stuff. He's not only an expert in this area, but his firm does all sorts of other personal injury cases. They do a great job. We know of the firm because we see them in a lot of the advertising and marketing that's done in Alabama, and they've done a great job. But don't try and go this alone. It's actually a lot more complicated than you think. Just because you think you slipped and fell at a grocery store that they're guaranteed to be on the hook, the reality is that's not necessarily true. There are certain rules and requirements and certain notices that may have to be provided. You want to get to a lawyer to be able to at least lead, guide, and direct you through the process to try and help you. Logan's a good example of a lawyer that can do that for you, and so we're glad to have him on. Thanks for coming on, buddy.
Thank you, my friend.
Really appreciate it.
Appreciate the time, and the thing we learned tonight, if there's a bobcat on your property,
Be careful.
you got to be able to.
Hey, look, there may be an issue there.
Oh my goodness. Hey, we're out of time. Thanks so much for the time. As we wrap things up, here's how you can continue the conversation with Hollis Wright. Thanks so much for being with us. We'll see you next time. Have a great week, everybody.
Thanks for watching The Attorneys, sponsored by Hollis Wright.